Okay, here we are again, continuing on with my last video in regard to basic estate planning documents and starting to organize. And organizing people is ultra important. As I said, people will affect you and your goals. Now, I did mention that the three basic estate planning documents are the will, power of attorney, and healthcare proxy. So I just wanted to add in a few thoughts in regard to those documents and organizing information and people planning. So let's start again with the healthcare proxy. So you'll remember that's the document that kicks in when you are unable to communicate with the medical health professionals, and your agent will step in and communicate and act on your behalf. Let's say that you are able to communicate with medical health professionals, but you want another person to inquire into and obtain protected health information. You can name an individual or individuals to do so in a HIPAA authorization. And let's say even the healthcare proxy has kicked in and you cannot communicate with medical health professionals. But remember, it's one agent at a time. And there is another person that you would like to be able to inquire independently with medical health professionals and obtain information. So allowing people to inquire into and access this information can be part of your planning, organizing information, organizing people, and then you would do this HIPAA authorization with your estate planning attorney. And often that's part of what I do with even just basic estate planning documents. We talk about the document, and if that's what they want and it seems reasonable, then we get that set up as well. Now, moving on to power of attorney, as you'll recall, that document allows you as the principal to name an agent or agents to act on your behalf in financial matters. And financial matters can be quite broad, and we can put in various authorizations and powers in that power of attorney document. And I wanted people to think about potential conflicts in life. And conflicts show up in all different ways, right? The people that you intend to benefit may start distrusting each other, questioning what's going on, what's being done. And one way to think about the power of attorney and planning and organizing information and people is to put in a requirement that the agent or agents account for their activities on your behalf to certain named individuals. And that can take place once a year, or twice a year, or once a month, or whatever you think. And perhaps that can take place, and you can put this in the document, with a professional. Having a consultation and review with the professional and the agent and other interested people can be one way to keep people planning in line with your goals and intentions. Because as we all know, we are talking about more than just assets. We are talking about people and your goals and what do you want to do. And so from keeping the train getting derailed, we can start thinking about arrangements that can be very beneficial. I had one circumstance where an agent tried to do some, I'll put it in quotes, cheap estate planning on his own and transferred father's assets to his own accounts, thinking this would be the easiest way to plan for his father. And no matter what he thought in his head, that is not what should have been done. Can you imagine what unfolded? Well, father passed, and shortly thereafter, the agent passed. The assets were then part of the agent's estate. And not only was the financial aspect of it a problem, but the mistrust among family members was obviously a huge problem. And the idea of keeping the family intact, keeping people on the same page really was just blown up. So thinking about basic estate planning doesn't necessarily mean we just do a quick document and be done with it. We think about what can be helpful in the situation. And this is really what I'm trying to get after in regard to this organizing information and people planning. And I also love this idea of people planning involving your team of professionals, because your team of professionals can help your team of family members, non-professionals, stay on the same page and keep everything in a good way, as opposed to things really falling apart. Now, another way to think about the power of attorney and organizing people is that you have to question, do you want the same person acting as agent under the power of attorney as the nominated executor in your will? When you pass, your executor could inquire into the actions of your agent. And certainly this would involve additional proceedings in surrogate's court. But if there truly is a conflict, in other words, that agent potentially did some things that should not have been done, and that needs to be investigated, and perhaps assets need to be brought back into the estate, there is that conflict there between agent and nominated executor. So if we don't have that wonderful planning that I just talked about in place, we need to then think about what are we doing here to at least arrange agent and executor not having a conflict, and what can be done in thinking about putting a person in both documents. And there's a lot to be said there. Now, I also wanted to then move into the will as far as people planning, and I wanted to bring up this idea of people who cannot act on their own behalf. So I mentioned last time that if you pass with minor children, then the surviving parent, if alive, is the natural guardian of person and property of that minor child, but that's in regard to ongoing lifetime matters. If there are going to be assets passing through the estate and there are minor children involved, then we're going to have a court-appointed person called a guardian ad litem. And the guardian ad litem may be on the front end, opening the estate, or on the back end in closing the estate. So if you have a will in place and you say everything to my surviving spouse, well, the guardian ad litem is going to be on the front end, ensuring that the will was done properly, reporting back to the court that it's okay to allow this will to move forward on behalf of the minor children who cannot act on their own behalf in surrogate court matters. The guardian ad litem gives that report, and then let's say the estate can move on and everything can go according to the will. But if there is no will in place, then we could potentially have assets passing to surviving spouse and minor children. And although surviving spouse might have priority to act under the priority statute for administrators here in New York, on the back end, we're going to need a guardian ad litem who's going to protect the children's interest to make sure that everything was done properly as far as the administrator actions, and that the minor children are to receive whatever amount, and then that amount will be held in a joint account with surrogate's court, and a guardian of property at that point must be appointed to handle those assets passing through the estate. So obviously, one, you want to have a will in place. And then two, sometimes there are things beyond your control as far as even needing a guardian ad litem appointed, even on the front end, as far as opening the estate and getting the executor appointed. But certainly a guardian of property would be needed in the event there is no will and assets will pass to minor children. Now, of course, the surviving parent in all likelihood is going to petition to be the guardian of property in that case. But, that depends on the situation. And sometimes that does make people cringe a bit. Let's say they know that the ex-spouse is going to be the one who's going to be potentially petitioning to be guardian of property, and that really doesn't sound good. So we have to make sure that, of course, we have a will in place and we have everything the way that you do want it. You may want to set up a trust on behalf of your minor children, again, in your will, which was mentioned in the prior video. Now, we could also have a guardian ad litem appointed for other individuals who cannot act on their own behalf. So we have people who are under a disability for one reason or another. We have people whose whereabouts are unknown, or who are even just unknown. And this goes back to that idea of who are your next of kin as far as opening the estate. Because if there are people who are under a disability or whose whereabouts are unknown, on the front end, we need to get that guardian ad litem appointed in some instances. In some instances, we needed to close the estate. So when you're going through your will planning with your attorney, all of these things, at least for me, are simmering in my head. And I'm trying to think about, geez, what's going to be needed at the time of a potential probate. And we could have some problems. I've actually had instances where I cannot get the individual wanting to do a will to get next of kin named. And obviously, I'm going to say we need other arrangements in place, because having an estate opened in surrogate's court is going to have a lot of problems. So always keep in the back of your mind that the will, the document, involves all of these other types of ideas. And we cannot just assume that because we wrote it on the paper, it's going to just be as easy and efficient as you would think in your mind. There's other processes and procedures that have to be followed. So I just wanted to bring up this idea that when we think about people and organizing information, having your mind open to understanding some of the ideas here is going to be very helpful as far as how you plan and how you organize your information and your people. So much more to be said, but just a few thoughts as I continue on with some basic estate planning concepts. So I hope this was helpful. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.